First-degree assault in Minnesota is the most serious assault charge we have. It's a felony. It carries a maximum of 20 years in prison. If it's done with on a police officer, there's a mandatory minimum of at least 10 years. What the prosecutor is alleging for first-degree assault is that you assaulted somebody and you caused them great bodily harm, or that you assaulted a police officer while they were working and you used deadly force against them. So if you just assault Joe Blow out there and cause great bodily harm, then that's a first-degree assault. If you assault an off-duty police officer, you still have to cause great bodily harm to be charged with first-degree assault. But if it's an on-duty police officer and they're working, then you have to use deadly force, and if you do that, there's a 10-year mandatory minimum. So for great bodily harm, what that means is it's defined in Minnesota law, and basically that means that you nearly killed them. To use the definition, it says that there's got to be a high probability of death from the injuries that you allegedly caused them, or a serious permanent disfigurement. So, if you cut off a limb of theirs, or they have to get something amputated as a result of the injury that you caused them, that could be a serious permanent disfigurement. You crush somebody's head, potentially gouging out their eye could potentially count, for example, or a permanent or long-term loss or impairment of any bodily member can also be great bodily harm. So if you put somebody in a coma, that's an example of a long-term impairment, or maybe one of their lungs collapses as a result, or they've lost the function of a kidney or something like that. That could be great bodily harm. The definition is a little vague, though. Sometimes prosecutors will overreach for what great bodily harm means, and that's called overcharging a case. A lot of times when great bodily harm is alleged, the first thing I'll do is investigate the level of harm and determine whether or not we have an argument that it's not great bodily harm. That's very important, because if we win on the argument that it's not great bodily harm, the charges will be lowered, and then you don't face as serious a consequences in the case. Obviously, there's other defenses besides whether or not it was great bodily harm or whether it was deadly force with a police officer, things like self-defense. It doesn't matter how much you harm somebody. If a jury finds that you were acting in self-defense, you're okay. And I explained self-defense in other videos. There are some requirements that you have to show in order to succeed in self-defense, but it is an option that should be looked at in a case, as well as alibi, lack of intent. If you're obviously the victim in a case, or they've pointed the wrong person, maybe there's problems with eyewitness identification. There are a whole bunch of defenses to these cases, but you better make sure you get a good lawyer that knows how to defend a first-degree assault case, one that knows not only to look at great bodily harm, or whether the prosecutors can meet the legal requirements and the probable cause for the charge, but then if they can meet that, how do you defend that in a trial and make sure that you don't go to prison for quite a while? If you've got any other questions, my name is Ryan Pacyga. You can check out my website at arrestedminnesota.com or call me at 612-339-5844.